Good afternoon, everyone. Distinguished guests and colleagues, and thank you for joining the Law Library of Congress and the United States Supreme Court for the 2026 Supreme Court Fellows Program Lecture. My name is Aslihan Bulut, and I have the honor of serving as the Law Librarian of Congress. It is my pleasure to send greetings from the beautiful Coolidge Auditorium of the Library of Congress's Jefferson Building to both our in-person audience and all of you watching us online. So let me just say a couple of words about the Law Library of Congress and this wonderful event today. The Law Library of Congress serves as the custodian of a legal and legislative collection of nearly 3 million items from all countries and legal systems around the world. Our skilled attorneys and law librarians provide research assistance and reference services on United States federal and state legal issues. And our foreign law specialists are a diverse group of foreign trade attorneys who provide foreign, comparative, and international legal research and analysis to all three branches of government. Our team is responsible for developing the collection for more than 300 legal systems, including foreign and international jurisdictions, as well as the U.S. states and territories in all formats. Each month, the Law Library hosts free webinars on topics concerning U.S. as well as foreign and international comparative law, and we invite you to sign up for these webinars on our site, law.gov. We are so honored today to have Justice Barrett with us at the Library of Congress, and I want to mention a little bit about our manuscripts division, which contains the papers of many of the Supreme Court justices, and the Law Library of Congress, which is a repository of the Supreme Court records and briefs, and a collection that we are excited to be digitizing. After the event today, we invite you to return to explore these wonderful collections. And at this time, I'd like to ask that you please silence your cell phones and refrain from taking any photos or video recordings of the event. And with that, I'd like to introduce the counselor to the Chief Justice of the Supreme Court of the United States, Judge Robert M. Dow, Jr.
Thank you very much, Aslihan. We are very grateful for the partnership with our neighbors, the Library of Congress. For those of you who walked over, it seemed like a lot longer walk today in the snow, but and we appreciate your generosity and again, hosting the Supreme Court Fellows Lecture in this magnificent auditorium. I am honored to welcome everybody here today in my dual roles as Counselor to the Chief Justice and also Executive Director of the Supreme Court Fellows Program. The Fellows Program is celebrating its 53rd year, and I am pleased to tell everyone in the audience just a bit about the program. The Fellows Program offers mid-career professionals, recent law school graduates, and doctoral degree holders from the law and political science fields an opportunity to broaden their understanding of the judicial system through exposure to the federal court administration. The Supreme Court Fellows Commission selects 4 talented individuals to work for one of 4 federal judicial agencies for a year-long appointment here in Washington, D.C. The 4 agencies are the Supreme Court of the United States, the Administrative Office of the U.S. Courts, the Federal Judicial Center, and the U.S. Sentencing Commission. All fellows gain practical experience in judicial administration, policy development, and education. They also benefit from time to study and write, and a vantage point from which to develop an academic research agenda. It's so wonderful to see so many of our fellows alumni in the attendance today, although I'll admit I can't see any of you right now under these lights. And I also am pleased to welcome all the finalists for our 2026-2027 Fellows class. Every class of fellows is unique, and this year's class is composed of talented lawyers and, more importantly, wonderful human beings. It is now my pleasure to tell you a little bit more about each of them. Addison Becker is the fellow assigned to the Supreme Court of the United States, where she serves in the Office of the Counselor. Addie joined the Fellows Program from the United States District Court for the Northern District of Ohio, where she clerked for 2 judges, the Honorable Philip Calabrese and the Honorable Benita Pearson. Addie earned her BA, summa cum laude, in English Literature from Capital University and a JD cum laude from the Ohio State University Moritz College of Law, where she served as editor-in-chief of the Ohio State Journal of Criminal Law. Keegan Coppola is the fellow assigned to the United States Sentencing Commission, the agency responsible for the establishment of sentencing policies and practices in the federal courts. Keegan joined the Fellows Program from the United States District Court for the Northern District of Illinois, where she clerked for the Honorable Ian Johnston. Keegan earned a BA in Communication in the Honors Program and also in Islamic Civilizations Societies from Boston College, and a JD, magna cum laude, from the Northwestern University Pritzker School of Law, where she served as an associate editor of the Journal of Law and Social Policy. Melissa Cosgrove is the fellow assigned to the Federal Judicial Center, the education and research agency for the federal courts. Melissa joined the Fellows Program from the United States District Court for the Eastern District of Missouri, where she was a career law clerk for the Honorable Stephen Welby. She previously clerked for the Honorable Stephen Clark and the Honorable Richard Weber, also of the United States District Court for the Eastern District of Missouri. She worked as an assistant attorney general in the Missouri Attorney General's office as well. Melissa earned a BS cum laude in business administration from Truman State University and a JD magna cum laude in Order of Coif from the University of Missouri Columbia School of Law, where she served as an associate editor of the Missouri Law Review. Samantha McCaleb is the fellow assigned to the Administrative Office of the United States Courts, which is the central support agency for the judicial branch. Samantha joined the Fellows Program from the United States Court of Appeals for the Eighth Circuit, where she clerked for the Honorable Bobby Shepard. Samantha earned a BM in vocal performance from New York University and a JD cum laude from Belmont University College of Law, where she served as associate editor of the Belmont Law Review. Addie, Keegan, Melissa, and Samantha, we appreciate your efforts thus far, and we look forward to seeing what you will accomplish in the remainder of your fellowship term. In addition to introducing the current class of fellows, I also have the honor of introducing our esteemed guest speaker. Associate Justice Amy Coney Barrett was born in New Orleans, Louisiana. She married Jesse Barrett in 1999, and they have 7 children. She received a BA from Rhodes College in 1994 and a JD from Notre Dame Law School in 1997. She served as a law clerk for Judge Lawrence Silberman, the U.S. Court of Appeals for the D.C. Circuit in 1997 and 98, and for Justice Antonin Scalia of the Supreme Court of the United States during the 1998 court term. After 2 years in private practice in Washington, D.C., she became a law professor, joining the faculty of Notre Dame Law School in 2002. She was appointed a judge of the U.S. Court of Appeals for the 7th Circuit in 2017, where she reviewed my work, among others. President Trump nominated her to be an Associate Justice of the Supreme Court, and she took her seat on October 27, 2020. Please join me in welcoming one of my favorite people for what I'm sure will be a very fun and far-ranging conversation. Justice Barrett. So welcome. Thank you so much for being here.
Well, thank you for having me, and thank you to the Fellows and the Library of Congress for hosting this event.
So we're going to start at the beginning. You grew up in one of our nation's iconic cities, New Orleans, as part of a large family. What was that like?
So well, gosh, there's a lot to say. I could occupy our whole time. So I think growing up in New Orleans, when I think about New Orleans, I think about family and food and fun. And the pace is slow, could not be more different from Washington. And we just passed Mardi Gras a couple of weeks ago. And I think Mardi Gras is a good snapshot of what the city is like. I think people who don't live in New Orleans think that Mardi Gras is a day. Mardi Gras is a weeks-long lead-up where there are parades every night almost during the week and on the weekends too. So it's like, did you finish your homework in time to be able to go out and see the parade that night? Mardi Gras Day is a big extended family thing. I'm the oldest of 7 children. I now have 7 children of my own. I'm kind of replicating my parents' life, I guess. I'm also the oldest of 29 grandchildren, and our big extended family would go out on what other cities call the median. In New Orleans, we call it the neutral ground, and set up ladders with benches on the top for kids to be able to sit and get beads thrown to them from the floats and picnic all day long. So I would say that it's easygoing and fun, and I really wanted to have that life for myself, just a life that was full of family and relationships and good times.
Did you want to be a lawyer growing up?
I'm not very creative. My father was a lawyer and my mother was an English teacher. So as I was growing up, I thought, being a lawyer and English teacher, you know, those seem like good options. I most of all kind of wanted to be a novelist, but I discovered when I took a creative writing class in college that I was not actually very good at fiction writing. So I abandoned that dream.
Did you ever think about being a judge or a justice when you were growing up?
I didn't. You know, I wasn't sure what I wanted to be. And even when I started law school, I mean, becoming a judge, sometimes I was a law professor for 15 years. And sometimes students would come see me in my office and they would say, I'd like to be a judge. And I always said, well, if you want to be a federal judge, that's kind of like lightning striking. I mean, it has to be, all the stars have to be aligned. There has to be a seat. There has to be a president who wants to appoint you and a Senate that's willing to confirm you. There's just, the likelihood of all those stars aligning is just very remote. And if you want to be a state court judge, you have to be prepared to go run for election in most places. So it wasn't really something that I was thinking about. You know, remember the family, food, and fun? I was kind of focused on, you know, I wanted to have a large family because I loved living in one, growing up in one. So I was kind of, I had my eye more on that, like how could I be a lawyer, how could I practice law, but also make it compatible with being a mother.
And so you migrated from New Orleans to Memphis to South Bend. How'd you end up in South Bend? How did you pick Notre Dame?
For law school or as a faculty
for law
member?
school.
For law school. So I decided, you know, I was debating between pursuing a graduate degree in English literature and going to law school when I was a senior in college. Law school won out, but I wanted to have ultimate flexibility. I didn't know what I wanted to do with a law degree, and Notre Dame offered me a full ride. And Notre Dame was very appealing to me for many reasons. You know, I'm Catholic. Notre Dame is a Catholic university. I liked kind of the support for my faith and it being kind of a whole person education. So I decided to do that and had a rude awakening when the first winter rolled around.
I was just about to ask, so growing up in New Orleans, had you ever seen snow before you went to college?
You know, once or twice it snowed in New Orleans, which meant like there were some snowflakes on a car when you walked out. When I was a kid, it was such a big deal when the temperature dropped below 32 that my dad would say, hey kids, let's put out some bowls of water and watch it freeze. So no, I was really not prepared for the climate in the Midwest.
And South Bend, for those of you who don't know South Bend is downwind of the lake, so you all get pummeled in ways that we don't even get in Chicago.
All winter long, yes.
And so when you left Notre Dame, you went on to 2 of the most prestigious and awesome clerkships in the country. You started with Judge Silberman. Can you tell us about how it was clerking for Judge Silberman?
I did. I really just lucked out. I clerked for 2 wonderful judges. Judge Silberman served on the DC Circuit, and he was the first. And Judge Silberman had had such an interesting career up to that point. I mean, he'd been a diplomat in then Yugoslavia. He had been in the Nixon administration in various positions in the Labor Department and the Department of Justice. He'd practiced law in Hawaii, and he loved to tell us stories from that. So he loved to talk, he loved to tell stories. Early on in the clerkship, he asked me if I was regularly reading Foreign Affairs magazine. I was not. And that was just an indication of the kind of things I had to be up on to be able to engage in conversation with him. But he was fun. He wanted to spend a lot of time with us. We spent a lot of time at the Department of Labor cafeteria for lunch because he was nostalgic about his time at Labor and loved that cafeteria. So not for the food, solely for the memories. So it was great. I learned a lot about the law, and I learned just a lot about Washington. I learned a lot about being a colleague, being a lawyer. So it was a great mentoring experience.
Next, you clerked for Justice Scalia. And was your interview with Justice Scalia the first time you'd been in the Supreme Court, or you'd been there before?
Oh, that's a good question. You know, when I was in high school, we did a senior trip to Washington, and I have a vague memory of being in the court at that time, but I know I interviewed with Justice Scalia when I was a law student, and it was certainly the first time I had seen the portions of the court that are closed to the public.
And how was that?
It was totally intimidating. I mean, you know, I'm a law student, and it's the first time I've ever met a Supreme Court justice, much less, you know, Justice Scalia, very big personality, extremely smart, you know, great writer. You know, I was in awe of him, and, you know, his clerks, the way that the Scalia interviews went was kind of a good cop, bad cop. And you went upstairs, and the law clerks seated you on one side of a table, and they sat on the other side, and they just pummeled you with questions for an hour. There was actually a manual at the time with like hard questions that you were supposed to ask the candidate. And then I talked to Justice Scalia after I went through that experience. And he asked me, and I didn't know this was coming, and so I'd given absolutely no thought to it in advance. If there was one area of the court's jurisprudence that you think we need some cleanup, what would it be? And if I had really been thinking, I would have picked an area in which I had some idea of what the solution would be. But instead I said, well, you know, I just think the religion clauses. It just seems like, you know, they're just so confusing, and the Establishment Clause jurisprudence on the one hand and the free exercise jurisprudence on the other. And he said, so what would you do about it? But I guess I did okay because he hired me anyway.
And then you spent a year there. What was that like?
So that was like coming into work, you know, every day especially every day that he was in, and you had to always be on your toes. It was like almost the same position that an oral advocate would be in the court, because he would just ask questions. He would ask you questions about cases without respect to whether the cases were ones that you were working on, and you had to be, you know, ready with an answer right away. You know, he had a larger than life personality. And I used to tell my clerks I used to tell my students rather, about the experience of being a law clerk, that walking into the court every day felt like such a privilege, and it was so awe-inspiring. I couldn't believe I was able to work in this building and, you know, see other justices walking in the halls, that all jobs after that had been downhill, because it was just such an amazing experience to work there.
Now, after that, you had law practice and professing and judging. Are there other people in any of those jobs that you've had that have been memorable mentors to you? And can you also talk about the importance for many of our younger lawyers in the audience here and some law students about the importance of finding good mentors?
Yeah. Well, I think Judge Dow, that you're asking me this question, makes it appropriate for me to say a mentor that we both had, which is Judge Flom. So Judge Joel Flom served on the 7th Circuit, and so I've had many mentors throughout my career, but Judge Flom is a mentor that's common to both of us. Judge Dow clerked for Judge Flom. When I went on the 7th Circuit, you know, there's no judge training. You just kind of show up, and then you have to start doing it. And Judge Flom had started out as a district judge. He'd been known as the boy judge because he was so young when he began. And he was on the Court of Appeals by the time I started. And he really took me under his wing. I mean, when we served on panels, we did not always agree. I mean, I can think of one case in which I wrote the dissent and he wrote the majority. So it wasn't that he ever tried to mentor me by telling me what I should do in a case or how I should write an opinion or how I should vote, but he helped me navigate the building. He helped me figure out how to handle relationships, and he just cheered me on. He wanted me to succeed, and he was really almost like a father figure to me, and I miss him dearly.
I can relate to that. And can you talk just more generally about the importance of finding mentors and maybe how it feels now to be a mentor?
I think it's so important to find mentors because much like when I walked onto the Seventh Circuit and had no idea how to judge, I mean, every person who starts any job for the first time doesn't yet know their way around it. I mean, that's true when you begin law school. It's true when you start, like if you start at a firm, there's a lot to figure out. And I think having a mentor, and I've had mentors at every stage of my career, from being a law student to being at law firms to being in academia to being, on the court. I think it's really, really important to have other people take the time to show you how to succeed, because nobody knows what they're doing in the beginning. And so I try to be mindful of that. I tried to be mindful of that as a professor with my law students. I try to be mindful of that now with law clerks. And I think that for people who are farther along in their careers, that generosity is really important because most people were the recipients of that kind of generosity at one point.
How did you start teaching? How did you get into that?
So as I said, when I was in college, I thought about either going on to get a graduate degree in English and being an English professor or going on to law school. And being a law professor allowed me to blend the two. I was a professor and a lawyer. I was interested in teaching. I was interested in the law and the idea of being able to write about whatever legal topics I wanted rather than just having to write about the topics that a client was paying me to write about. I was unsure, when you go on the teaching market, you are at the mercy of the market and where you get a job. And I did not like lacking control over where I would wind up living. So the idea of just kind of going on the teaching market and having to take interviews all over the country didn't really appeal to me, but I wanted to try out teaching, so I took a fellowship and I worked at GW Law School for the year of the fellowship, working on scholarship and thinking about it. And then I really lucked out because I didn't end up having to go on the teaching market. Notre Dame found out that I was interested in teaching and that I was doing this fellowship, and they called and asked if I wanted to go and interview before I went on the market, and I did, and they offered me the job. And my husband, Jesse, had also graduated from Notre Dame, and we loved the university, so it was an easy sell for us to go there, except for the weather.
But you survived a long time.
I did survive a long time.
So we first met in 2010 as members of the Advisory Committee on Appellate Rules, and many people in this room probably do not have any window into the rulemaking process. What did you think of the time you spent on the Rules Committee?
So the Rules Committees, and there are several, help fashion rules for the federal courts to follow. You also spend time on civil rules, and so that's the trial court rules. Those get a lot of action. Judge Dow and I served on the appellate rules committee together, and I was a law professor at the time, so I was the academic representative. And it was a really impressive experience. It's people who take that process very seriously. There were top appellate lawyers, there were district judge, usually they have state Supreme Court justice, they have appellate judges from all over the country who are really trying to get it right, really trying to make it fair. It was a very collegial experience. So I came away very impressed with the way the process worked.
And a tip for those of you who might want to be on the Supreme Court someday, if you lined up all the professional accomplishments of the justices, probably the one they most have in common is not where they went to school or who they clerked for, but that they were on the Appellate Rules Committee. That's a very
that actually is kind of true.
So you mentioned your husband, Jesse, who's also a lawyer, and he spent a number of years as a prosecutor, and now he's in private practice. And you previously mentioned also that you have 7 children. How do you guys make it all work?
Oh, teamwork. Whenever I'm asked this question, I always give the biggest shout out to Jesse, who's here today, because without the teamwork and without Jesse really doing more than his share, we would not be able to pull it off. We make the kids a priority. We have family dinner most nights. And Jesse once said that our Google Calendar looks like a piece of abstract art because there's just so many colors and so many shapes all over it. But we try to be very organized. This morning I woke up at 4:30 You know, we maybe like cut a little sleep here and there to try to make it all happen. But I will also say that, you know, when you have a large family, they're not all the same age all at once. So we don't have 7 toddlers. You know, our oldest is 24. We've got 2 in college, and then the others are in high school and middle school at this point. So it's not quite the intensity. I certainly could not have done the job that I have now when my kids were all in grade school.
You talked a little bit earlier about your transition from the academy to the bench and having good mentors. How did you did you find the work all that different?
It's interesting that you say that, because in some ways the work is remarkably similar. When I was deciding whether I was open to the 7th Circuit nomination, I talked to a good friend of mine, who also happens to be a good friend of yours, who was a Court of Appeals judge. But he had come from practice. So if you're coming from practice, you're used to a frenetic pace, you're used to a lot of meetings, you're used to a lot of phone calls. And he said, this is just so quiet. If you do this, you would have to be prepared for it to be quiet. He said, my phone doesn't ring, and when I get messages, I save them up for the end of the day so that I have something to look forward to. But a law professor doesn't get that many phone calls either. So when I actually shifted from Notre Dame to the 7th Circuit, a lot of things were remarkably similar. Law professors spent a lot of time writing and then reading and writing, interacting with law students, and law clerks are pretty young. I mean, they're relatively young lawyers, not that long out of law school. So for me, there were many things about the rhythm of the day that were not that different from the rhythm of the day that I had as a law professor.
You should sit by designation in district court for a while. And then how about going from the 7th Circuit then to the Supreme Court, which happened very quickly in your case. How is the rhythm different there, if at all?
So I would say the rhythm, in some ways the rhythm is the same, because the job of a Supreme Court justice is essentially as an appellate judge. And so the meat of the work is the same meat of the work that I had at the 7th Circuit, which is reading briefs, interacting with law clerks, doing, writing opinions, attending oral arguments. So that is the heart of the Supreme Court's work. But the 7th Circuit, you're operating less in the public eye, you're not so much a public figure, and there's not a need for security and all of that. So I would say that the work of the Supreme Court, one of the things that struck me the most about the difference is that you're really just kind of doing law behind closed doors, maybe saving up your messages for the end of the day when you're a Court of Appeals judge. When you're on the Supreme Court, you're doing all of that, but it's really very much happening kind of under a microscope.
You have written a wonderful book called My Life in the Law. And in that book, one of the statements that I read that caught my eye was, collegiality is an act of will. I thought that was really cool. What do you mean by that?
You have to decide it and try. I mean, I think in any human relationship, it's a big mistake to let emotion be your guide all the time. Because if you just treat people the way that you feel, you will not always treat them very well, right? So I think that you have to decide. When I started at the court, maybe this is a good way to sum it up. When I started at the court, one of my colleagues shared advice that another colleague had shared with this colleague. And that was that it's most important to go to lunch. We have lunch together after oral arguments, and we have lunch together after conferences. That it's most important to go to lunch with the other justices the day after a difficult conference vote. So if you are on the losing side of a case and you're very disappointed by that, if you were going to go with your feelings, if you were going to do what you felt, you would just head back to your office and maybe kind of like stew in your disappointment for a while. But if you are going to really make an effort and make a decision to be collegial and to cultivate a relationship with your colleagues, you will make the decision as an act of will that you will go and spend that time with them at lunch. And I think that's true in relationships generally, and I think that's true of colleagues, both in my job, but at other jobs. You really have to decide how you want to treat people, you have to decide that you want to be collegial, and then you have to follow through on the commitment that you make.
You've also written a lot about Chief Justice Marshall, And Chief Justice Marshall was certainly an exemplar of that whole idea of collegiality being an act of will, and using it not only to develop relationships on the court, but all the foundational cases in our jurisprudence, the history of our country. I've heard Chief Justice Marshall described as having had a greater effect on the history of our country than a lot of presidents have had, although he's outside the legal world a very underappreciated and understood person. Would you agree with that assessment? And if so, can you talk about what made him so influential?
Let's see. So I'm not sure if he's had a greater effect than any president, but he certainly had a remarkable effect and an indelible imprint on the Supreme Court in particular and the judiciary more generally. I mean, Marshall was appointed literally on John Adams's way out the door. So he had been John Adams' Secretary of State. John Adams appointed him to be Chief Justice after the Federalist Party, of which both John Marshall and John Adams were a part, was completely routed in the election of 1800. And Thomas Jefferson and the Democratic Republicans took over both the presidency and Congress. So when Marshall, I mean, remember, the country is pretty new. We're talking 1800, 1801, when Marshall went on the court. And the court itself had not been really established as a strong institution. Its jurisdiction was very narrow. It didn't hear cases that often. It didn't have a building of its own. And Marshall comes in, and he's facing a president who really hated him. Jefferson was not a John Marshall fan, and he's facing a hostile Congress. Threats of impeachment were constantly hanging over his head and the head of the other justices. And Marshall is regarded as such a great Chief Justice because of the way he navigated those relationships with other branches and the relationships inside the court to establish the court as a strong third branch of government. He was really brilliant at it. I mean, and we're talking about collegiality though, so I'll focus on that. I don't think that Marshall could have accomplished what he did in establishing the court's strength vis-a-vis the other branches of government if he had not been able to unite the justices as colleagues on the inside. You know, at the time, the justices actually spent most of their time riding circuit, which was in their own geographic areas, sitting with trial judges essentially and adjudicating cases. They weren't hearing cases as a court together that often. So they didn't live in Washington, say, or in Philadelphia. They would come and they would stay at boarding houses, and they would all, there was no common place for them to work. When they heard argument, they did it in borrowed space in the Capitol building. So Marshall instituted a practice by which they would all stay in the same boarding house. They would eat dinner together. They would enjoy Madeira after dinner together. And he built up collegiality and relationships in a way that made the Supreme Court a cohesive unit. And in what must have truly been a feat, at the time that Marshall became chief, the court did not write opinions just for the court. So you wouldn't say that there was one majority opinion. Every justice wrote his or her, well, own opinion. It was called seriatim opinions. Each one just said, well, this is how I see the case, this is how I see the case. Marshall not only persuaded his colleagues to end that practice, he managed to kind of say no separate opinions whatsoever. And you can't, when I was in the academy, being dean of any school, and in my case a law school, was described as herding cats because people have life tenure, and so you can't really tell them what to do. That's how it is for a Chief Justice and his colleagues. Marshall wasn't the boss, he wasn't in charge, so he couldn't say no separate opinions allowed. Because he was well liked, just by the force of his personality, he managed to have everyone stop writing separate opinions. So there was one opinion for the court, and concurrences and dissents were actually quite rare, which I think was part of what enabled him to establish the court's strength.
That is a perfect segue to my next question, which is, I think there's a common perception that there aren't very many 9-0 opinions. That's actually not true. Most of the opinions that have come across my desk this term so far, many of them at least have been 9-0 with no separate writing. How do you decide when to write separately, or what's your process in thinking about that?
Yeah, I'll say one thing, an in response to your comment about unanimity, I mean, generally cases we hover around 50% for unanimity, which, it's sometimes a little above, sometimes a little less, but, that's generally the rate of unanimity for the court, not just in the current court, the Roberts Court is currently constituted, but before that too. How do I decide when to write? Well, if you are in dissent, and you're just asking about separate opinions, right?
It could dissent, concurrence, whichever.
Okay. So if you are in dissent, the practice would be that the most senior justice in the dissent will assign the primary dissenting opinion. So sometimes if I write a dissent, it's because whoever was the most senior justice in the group of dissenters has asked me to write it. So that you're still writing kind of on behalf of a group. There are other opinions in which you write because you choose to write, and that might be when I write just a separate dissent that's speaking only for myself, or maybe like one or two other people who join it, or a concurrence. And I try not to write too frequently the separate opinions. I kind of like the way John Marshall said seriatim opinions are out, so I generally try to just let the majority opinion speak for the court's opinion speak for the court. But sometimes I will write a concurrence or my own dissent if I have something that I feel like I should explain, something about my position that I feel like warrants explanation so that it doesn't look inconsistent. If I don't join the full opinion, I usually write to say why. And if I feel like I have something to say that would add to the development of the law, something that I hope that lawyers and other courts will think about, or that law professors might help us by writing about or doing some research in, that's the situation in which I'll write a concurrence. I try to resist the temptation to write one because I feel like I could have said what the majority said better.
Very good. So we talked about John Marshall a few minutes ago being perhaps an underappreciated person in our history, but you have a portrait of a special individual in your chambers who is also underappreciated in our nation's history. Can you tell everybody who that is and why you've got that portrait prominently hanging in their central office?
Yes, it's Abigail Adams. So it's the 250th anniversary of the United States this year, as you all know. And I spend a lot of time working with the Constitution and a lot of time thinking about the history of the Constitution and its founding. And so when I joined the court and was thinking about what to hang on my walls, I really wanted to hang a portrait of someone from the founding era. But I really wanted it to be a woman, and obviously there were no women in the Continental Congress, there were no women in the Constitutional Convention who participated. And I think actually, I think it's Coney Barrett who has this book, Founding Mothers, which is a really great book. But I mean, when you think about who were the influential women at the time, I think Abigail Adams was just remarkable. And I identified with her in many ways. I mean, Abigail had a large family. She had 5 living children, but she was a sharp observer. She was basically self-educated and home-educated, but she was a sharp observer of the politics at the time, a fierce patriot. We have so many of her letters which reflected her insight about the day, her influence over her husband, who did have a large role in the affairs of our fledgling government. So I really admire her, and I admire also, on a personal level, the way that she had to, they were married, they were living in Braintree, Massachusetts. They had to go to France when he was a diplomat in France. Then she was thrust into the public eye when her husband became the vice president. She was only the second, wife, the second first lady, following in Martha Washington's footsteps. And so I think about all of the ways in which she herself was a trailblazer, even though she was limited by the limitations that all women faced at the time. And I kind of like what it says about the country and the Constitution to have her in my office and have the contrast. I can do, I say in the book, I can do what she could not. I am a mother and I have many children, but I also hold, an important public office in the United States government.
You mentioned the Constitutional Convention a minute ago, and in your book, you import a New Orleans term, gumbo, and you describe the gumbo of personalities of the Constitutional Convention. Can you say a little bit more about that?
Sure. When you read about the convention, and when you read about what the conditions were like at the convention, I mean, we're talking about, the men who were at the Constitutional Convention were generally, I would say, drawn from the same kind of segment of society. I mean, they were generally educated and they were generally well off. But they were different in so many ways, too. I mean, there was a delegate from New Jersey. He was the youngest. I want to say that maybe he was 26. Benjamin Franklin was 81. You know, you had people who were abolitionists. You had people who were slaveholders, people from the North, people from the South. They had competing interests. And they also, and this is like one remarkable thing when you think about the conditions under which they were working, you know, they were supposed to be just amending the Articles of Confederation. And they didn't want it to get out that they were now embarking on this enterprise of creating an entirely new, founding document, our Constitution. They kept the windows closed in Philadelphia in the summer without air conditioning in Independence Hall. And they're wearing long sleeves, they're wearing the clothing of the era. It's not like they were showing up in like gym clothes. I can't imagine how stuffy that room must have felt or how smelly it must have been. And so they're thrust into this small space. Many didn't know each other before. And in that kind of hothouse environment, they managed to produce this document that is now the oldest written constitution in the world.
Why do you think our Constitution survived for so long? Is there some special sauce there?
I think our Constitution has survived for so long because of the way in which it was written. So call this, the miracle at Philadelphia or the genius of the founders. It is a combination of the specific and the general. Most of the Constitution is written in more general terms. And I guess maybe I'll say it this way. When I was teaching constitutional law, I used to ask my students, and I sometimes do still when I teach a seminar, which I occasionally do, I ask them to read the Constitution of Ecuador. And I picked that one because I once went to Ecuador and spoke to people at the Ecuador Supreme Court. And I was struck then by how thick it is. It's very thick and it is very detailed. Contrast that with ours, which can be put in your pocket. The framers had the wisdom to not try to put too much in the immovable document, the one that would be harder to amend. Most of it left to the nimble legislative process. So for states to work out, for Congress to work out, if we tried to have environmental regulations, for example, or a lot of details about the tax code in our Constitution, it would get out of date very quickly. But because of the way it allocated power and because it delegated so much to the legislative process and the political process at both the federal and state level, we allowed that change to happen and evolve through our legislatures. And I think the Constitution itself balanced well our fundamental commitments that we don't change without much more work, commitments that are expressed in the Bill of Rights, and the commitments that are structural, and say Articles 1, 2, and 3 of the Constitution. And I think that blend, you need to be specific about some things, how legislation gets passed, because you can't be reinventing the wheel when you figure out how many votes it takes in Congress to override a presidential veto. So we have those kinds of things being very specific. But for all the policy-making decisions, largely that's left to the legislative process.
Obviously, you work with the Constitution all the time. Does the Declaration of Independence ever come into your thinking as a justice?
So I think, obviously, the Declaration of Independence, which we celebrate this year, lies at the bottom of all of it because it launched the project. But Abraham Lincoln described the Declaration as the promise and the Constitution as the means for fulfilling that promise. So most of my work deals with the means and the mechanism. So the Constitution is what has legal effect. So if we think of the Declaration as expressing our aspirations, the Constitution is the document that governs us.
The last part of your book is really about thinking about the law and how you think about the law and how it stimulates thought for all of us to think about the law. And in that part of the book, you tell this story about your grandparents exchanging letters during World War II and how that sort of affected the way you look at interpretation. Can you share some of that story with the audience here?
So my grandparents lived in a house that my grandmother's aunt had actually built. I mean, one thing that I loved about New Orleans is that it tended to be, at least before Katrina particularly, that people stayed there for generations. So in this house, my grandparents had both passed away by the time that Katrina hit. My great uncle was then living in the home. And Katrina flooded the house. It went up to the second story. I actually have my grandmother's piano, and that piano was on the second story, and the watermark is still there. It rose kind of to the foot of the piano, a few inches up. And we don't have basements in New Orleans because it's below sea level, so the basement is really kind of built up like a first floor. So in the basement of that house, which was essentially kind of first floor storage, was my grandfather's Navy duffel. He served in World War II in the Navy. And the water carried it out, and when my family went out to try to clean up the wreckage from Katrina, my uncle and one of my cousins found this duffel bag, and because it was meant to, resist water, the contents of the bag, which were these letters that my grandparents had exchanged during the war, were intact. I mean, some of them had to be laid out to dry, and one of my aunts undertook the painstaking project of transcribing all of these letters for the family to have, and then ultimately bound them into a book, which we all have now. And I used that story in the book to talk about how interpretation and language work, because sometimes people say, well, what does it mean to be a textualist or an originalist when you handle legal documents and when you think about words? And I think what that means is that you interpret words as they were understood by the people who were using them and understood them at the time. And when you read my grandparents' letters, Cimarron was the name of his ship. Or he talks about events, he will share events in the letters, but understanding the context in which he wrote, knowing something about the vocabulary of where he was, it's what enables us to kind of reach back in time or get that snapshot into what their life was like. And so it struck me as a way, many of the things in the book are many of the things I think about because my family was important to me growing up. I tend to draw in those kinds of examples when I'm trying to explain things.
You've spoken before about in your grandmother's lifetime, and I'm not exactly sure how many years that was, how many times the Constitution was amended. Of course, the Constitution has not been amended for something like 35 years now. Can you talk a little bit about how you see Article 4? Article 4?
Yeah.
Articles 1, 2, and 3 are quite obvious for probably everybody in the room here, but how you see that process and fitting into, I guess, the overall enterprise that we've been engaged in for the last 237 years?
Well, so I opened the book with this description of my great-grandmother's house. And as I was writing the book and was just thinking about what her life was like, I just decided to count up how many times the Constitution had been amended in her lifetime. And now as I'm sitting here, I can't remember how many it was, but it was a surprising number. And we often say now, as Judge Dow says, we haven't amended the Constitution in something like 35 years. The 27th Amendment was the last time. We often say, man, our Constitution is just unamendable. Nothing will happen. It's too hard to amend. And so it struck me that the Constitution had been amended so many times in her life. And it makes me think that something about our political climate has changed, that maybe agreement was easier to reach then. The country is also bigger. There were many states that entered the Union. She was born in the late 19th century and she died in the 1950s. After Brown versus the Board, because one of the things that struck me is she was born in New Orleans, just a few miles away from where Homer Plessy couldn't get on the train or couldn't sit in the car during segregation in the same car as white people. And she lived through Brown versus the Board and desegregation in the South. And two of her sons, one of her sons especially, who was a bishop, was active in desegregating the New Orleans Catholic schools. So that whole span of her life, she saw great change, but including the admission of several states into the Union. So we're a bigger country. I guess in some ways we might say that we're a more complex country. And Article 4 of the Constitution sets a pretty high bar for amendment, and I think it's a delicate balance to strike. I don't think we want the Constitution to be so easily amended that it's no different from legislation. But maybe it's the case, Justice Scalia used to say that he thought the Constitution ought to be a little easier to amend anyway, because the bar is so high that ends up putting a lot of pressure on courts to do the updating for us.
You just mentioned Plessy and Brown, and many of the people in the room here have probably been across the street to our building and they've seen the Cooper Bench exhibit, and we have an exhibit there where there's a 13-minute film that features the 9 active justices plus Justice Breyer. And they tell the story of Worcester versus Georgia, which is the case that the Cherokees won just prior to being removed by President Jackson. And then Plessy and Brown and Cooper versus Aaron, which is the Little Rock desegregation case. And one of the lessons of that film is how important it is to respect the law and to follow the decisions that you agree with and to follow the decisions you don't agree with. And in your book, Justice, you talk about how we cannot legislate a culture of respect for the law into existence. And can you talk a little bit about how we might foster a culture of respect for the law if we can't legislate it?
Yeah, you can't make people respect the law. And I think a lot in our society runs on norms. You can't catch everybody who speeds on the highway, just to give an example. If everybody felt at liberty to just drive 80, the police can't enforce all of that. I think a lot in our society, when we think about constitutional provisions that are more important than speed limits, like the freedom of religion, freedom of speech, for example, all of those things are important, but look, the courts can't be the only guardians of those rights. A lot depends on elected officials who also take an oath to uphold the Constitution. And elected officials respond to what their constituents want. They respond to what the people want. And if people revere the Constitution and if people revere the law, that lends itself, that fuels, I think, a culture in which law is respected. And I think if we internalize, we have to think about the kind of America that we want. We've committed in the Constitution, which is our foundational document. It's one that it represents what our supermajority has agreed to, because the Constitution had a high bar for ratification, it has a high bar for amendment. And if we have really committed to these ideals, freedom of speech and freedom of religion commit us to pluralism. They commit us to tolerance. They commit us to having to respect and allow to be heard even those viewpoints that we might disagree with, even those viewpoints we might find abhorrent. And the more pressure there is in society to, even in private places where the Constitution doesn't apply, to squash out a commitment to pluralism and squash out a commitment to respect the ideas of others, the more that our public institutions will respond to that too. And so I think that respect for the law, reverence for the Constitution really begins with American citizens. And so I think it's really more of a trickle up than a trickle down.
We have a lot of younger lawyers here today. We even have some students here today. What do you tell people who you encounter who are thinking about law as a profession or a career? Are you bullish on that? Are you skeptical about that? What do you tell people?
Is this an AI question?
It is not, because I don't even know how to use ChatGPT. You may recall a few years ago when the chief's year-end report was on artificial intelligence, and one of my kids showed me how to use ChatGPT, and I said to it, give me 2 paragraphs of Chief Justice Roberts' voice about, and I said, Chief, I've drafted the year-end report. He looked at it and said no. So, no, that is not an AI question.
Not an AI question. I think the law is a great profession. And so, if you're asking if I'm bullish on the future of the law and the legal profession, yes. I think lawyers have done great things for our country, and I think they will continue to do great things. And I think it's been a great life for me. It's been a great life for my husband. I don't think it's a great life for everyone. So, one of our daughters was thinking about going to law school, and I would give young lawyers the same advice that I gave her. Make sure it's what you really want to do. Just don't default into it because you think, hey, I majored in the humanities and, this seems like it'd be kind of good. It's a lot of debt, and it can be a lot of hours. And so before you undertake the opportunity costs of not working in some other job and earning money for 3 years and then assume the debt that law school will be, I think it's a big investment, and you should think about it as a big investment and decide if that's where you want to put your time, talent, and treasure. Is that what you want to invest in? If you decide that it is, I'm bullish. I think the law is fun, and I think the law is really important, and we need good lawyers.
I agree with all of that. And I would, what do you think lawyers do really well for our society as a person who's bullish on the profession?
So I think that to the extent that lawyers help people navigate hard problems, everything from people who are navigating civil things like buying houses or businesses, starting businesses, taxes. there's so many things about daily life that lawyers help with, and then of course on the criminal side as well. But then when you think about public law, when you think about the way that lawyers help keep our institutions running, our institutions of government, I think that the law in many ways, because it orders our relationships, both our private relationships to one another when we think about property, business, and all of that. And then it orders our relationships of the federal government to the state government, of Congress to the president, of the scope of the Supreme Court's power. Lawyers have the ability to affect all of that. And when they do it well, I think that they can really be instrumental in helping society thrive. If they do it poorly, they can tear it down. And I guess what I would say that one thing I was asked this question recently, like what could those who are lawyers do to help society thrive? Apart from being great at the practice of law, I would say, Judge Dow, you asked me a moment ago about what it means to have a culture of respect for law. I think it would be great for lawyers, when you're at a dinner party or when you're interacting with people, to reinforce that and to speak in a way and to celebrate the law, to celebrate differences, and to model the kind of respectful disagreement that I think lawyers are good at because they spend a lot of time arguing, and the best lawyers know how to argue without alienating people.
In our audience today, we also have a lot of law clerks. You've now had law clerks for quite some time, and I think you have 4 now. Can you talk a little bit about what role the clerks play in making your life better? I certainly miss mine. And anything that, I would say there's probably 50 people in this audience who either are now or have been law clerks.
Well, my 4 current law clerks are here, so I have to say they make my life better in every single way. Law clerks are a lot of fun. So, I was a professor for a long time, so I love being with people who are just starting out their legal careers. A lot of people are surprised that law clerks, for district judges, Court of Appeals judges, Supreme Court justices are so new in their careers. But I think that's as it should be, because it makes, it helps ensure that it is the judge who is in the driver's seat. Because it is, Judge Silberman used to say, it's my commission that's on the wall. That the responsibility has to lie with the judge. But clerks are so helpful in the process. I have 4 times the cases to manage that they do. They divide up our cases by in fourths. And everybody has a sense of what's going on in other people's cases, but one law clerk is primarily responsible. And so will write me memos summarizing the cases in the law, and those are great, especially for the morning before argument, because I've got a lot, on my mind at that point. And in the weeks leading up to argument, I can debate the cases or ask for further research about the cases. Law clerks help with drafting. Law clerks check work. Law clerks help handle a lot of the things that come flying into the court. You might have heard that we're having a lot of these emergency motions and interim motions these days. So law clerks help channel that work and keep justices abreast of what's coming in. And they are someone that, the law clerk in charge, I can talk to all law clerks about it, but the clerk in charge is the one who is down in the weeds with me, and so can help me think it through as we're going back and forth.
It reminds me of something Judge Flom used to say to us, which is, each of you have 1 vote and I have 4. In the conclusion of your book, you write that no generation starts afresh. Each is shaped by its predecessors. And you've already talked a lot this afternoon about how your family sort of shaped the way that you view things, and not only in your profession, but in your personal life, and trying to keep all that straight. I'm just thinking more on a global perspective, or maybe on a perspective of how the court might play a role in how you might see some of your predecessors or role models helping shape the way you do things. Not in your family, though, I'm talking about professionally.
Yeah, so I think of my seat on the court, that I am the current caretaker of seat that has been held by many other people before me, and that will be held by others in the future. So I think that the current occupants of these seats, the 9 of us, we are working for an institution, and we are trying to care for an institution that our predecessors have passed down to us, and that we will pass down to future generations of Americans. And I think we are very lucky, not just in the courts, but just in America generally, that we stand on the shoulders of those who have contributed to America, and in my neck of the woods, the law, the Constitution, and given us such a strong and rich foundation to build on. And so when I think about what I've inherited, what we have all inherited in terms of the place of the court in our government, in the strength of the Constitution and all of the precedent that has built up over these last more than 2 centuries, I think that I want to hand that off to those who come after me in better shape than I found it.
You wrote that Judge Silberman taught you that relationships are part of the work, not a distraction from it. We've talked a little bit about that, particularly with your colleagues, but how does that relate to your life in toto?
So I am very focused on efficiency. You asked me how Jesse and I make it work, and I am trying to squeeze the most out of every day. But that's also just kind of part of my personality. I was not married when I clerked for Judge Silberman, but I still kind of felt that way. I was always focused on the work. One of my great regrets, honestly, from my clerkship at the Supreme Court was that I never attended Justice O'Connor's exercise class. She used to have an aerobics class in the mornings a couple times a week. That was at something like 8 a.m. And I was always thinking, I've got to finish this bench memo, I have to finish this draft, I have to finish this cert pool memo. And I missed out on that, and I wish I wouldn't have. So Judge Silberman, even though I'd already clerked for Judge Silberman at that point, I should have learned that lesson before I missed out on the aerobics class. Judge Silberman spent a lot of time socializing with us, talking to us, being in our offices, joking, eating lunch, that sort of a thing. And it acculturated me to the idea that it can't just be about the work. It can't just be about sitting at your desk and making sure that you've read all the briefs, read all the cases, you're sitting there as a lawyer, you're in front of your screen on Westlaw all the time. That relationships are just as important. We talked earlier about collegiality. It can't happen. You're not a brain that's separated from a heart and a body and personality. I mean, we all operate within a web of human relationships, and goodness knows that I hope that my job's not replaced by AI at any point in the future. But I mean, judging is a human enterprise, and all of our jobs are. And in the law, when we're lawyers, we're doing this all for humans and to human ends, and we're all working together with other people as part of that enterprise. And to try to cut it out and make it just an intellectual exercise or about the work only impoverishes it and just strips it down.
We work in a really amazing building.
We do.
And we have a lot of visitors who like to see that building. I imagine you've given more than your fair share of tours. I have as well. What do people say is their favorite part of a tour at the Supreme Court?
Well, that's easy, like hands down. It's the highest court in the land, which is our basketball court that's up at the top. People are just blown away by the idea that there's a basketball court in the Supreme Court up at the top. I mean, that's when my kids come, if they bring friends, to say that's all really they care about seeing. Yeah.
They don't want to sit in the courtroom?
I mean, yeah, I guess so. But I mean, lots of people have seen the Supreme Court courtroom. Fewer people have seen the highest court in the land. So it's definitely the basketball.
It's not too late for the aerobics class. I think it's now known as
suggesting
Zumba,
that
whatever that
one?
may be. I'm only going to invite you to play basketball. I don't do any
You're
other
not going to
things.
invite me to do aerobics? Okay.
No, I don't do those either. I walked in on one once, and it occurred to me that I wasn't particularly welcome. I was dressed like this, so it probably wasn't my day for that. I want to thank you so very much for your time and your wisdom and your book, and being an all-around wonderful presence as a justice in our building, and certainly for your time today. And we will look forward to seeing you and Jesse tonight as well. So thank you so very much for this. Appreciate it.